Hello, I'm Matt Davis, a shareholder with Mills Pasker Divers in Tampa. My practice is focused on construction and surety litigation, including bankruptcy litigation when my surety clients get involved in bankruptcy matters. Today, I'm here to discuss the topic of venue under the Bankruptcy Code and what arguments you may have if you find yourself in an unfavorable bankruptcy venue. Before we get started, I'd like to thank Allie Adams. Allie is also a shareholder here at Mills Pasker Divers. She invited me to work with her in writing our chapters for the book, and I am grateful for the opportunity. In the chapters that Allie and I wrote, we covered an overview of the bankruptcy process and jurisdictional issues such as core versus non-core jurisdiction, venue, arbitration clauses, and the bankruptcy appellate process. These are all important topics that can impact a surety if and when it finds itself before a bankruptcy court. But today we're going to focus on two interrelated topics that we discuss in Chapter 3 of the book, venue and forum shopping. This is important because debtors have been known to forum shop in favor of debtor-friendly jurisdictions or to otherwise select districts to knowingly inconvenience creditors. First, I do want to go over some general background on venue under the Bankruptcy Code. Two statutes govern venue and bankruptcy actions. That's Section 1408 and Section 1409 of the Bankruptcy Code. Today we're going to focus on Section 1408 of the Code, which governs venue for the initiation of proceedings. Generally, under Section 1408 of the Bankruptcy Code, venue is proper in the district where the debtor's domicile, residence, principal place of business, or principal assets have been located for the largest portion of the proceeding 180 days before filing. Any of those four bases is sufficient to establish proper venue. Subsection 2 also provides a fifth basis which allows a debtor to file in any district in which the debtor's affiliate, general partner, or partnership has a pending bankruptcy case. So as you can see, the statute provides plenty of room for lawyers to argue and earn their keep. And given that any of the factors establishing venue and the 180-day requirement, this also creates opportunities to establish venue in districts the debtor would otherwise not appear to have any ties. So why is this important? Because one of the obstacles that bankruptcy courts face is forum shopping, in which a debtor files in a district that it believes is more debtor-friendly or is obviously inconvenient to a certain creditor or creditors. As mentioned, Section 1408 provides a lot of leeway for debtors' attorneys, of course with some planning, to get creative in where their debtor is deemed domiciled for purposes of establishing venue. Now, perhaps not surprisingly, there is a perception that larger bankruptcy courts are eager to be seen as the most prestigious and well-equipped bankruptcy litigation courts, therefore perhaps leading them to let forum shopping slide in order to get their shot at the more complex cases. Accordingly, you will see some debtors go to extraordinary lengths to forum shop their way to a more favorable district. It is not uncommon to see related entities or affiliates using their association to effectively forum shop. Some even go as far as creating a new entity solely for the purpose of filing in a particular district. Now, despite the willingness of some bankruptcy courts to hear and decide cases with limited ties to their districts, courts have and will draw the line in the interests of justice or for the convenience of the parties. So how do you go about seeking a change of venue if you believe the debtor has engaged in forum shopping? And that answer is found in Section 1412 of the Bankruptcy Code, which, as you can see from the slide, is very short. Section 1412 applies even if the venue is technically proper because the debtor meets the requirements we just discussed under 1408. Section 1412 allows a party such as the creditors or the trustee to seek a transfer of venue under two circumstances. The first is when the transfer is in the interest of justice, and the second is when the transfer is for the convenience of the parties. Now, obviously, as with Section 1408, this statute gives lawyers a lot of room to play with. But keep in mind that the party seeking to transfer venue bears the burden of proof to establish the elements under 1412. A relatively recent case out of the Southern District of New York Bankruptcy Court, which does involve a surety, provides a fantastic illustration as to how a court applies Section 1412. And this is the Dunmore Homes case. Now, Dunmore Homes involved a California home builder that since its inception had been located in California. It was headquartered in California, had all of its operations in California, all of its employees were in California, and 24 of its 30 largest creditors were based in California. Now, despite these strong connections to California, a few months before filing for bankruptcy, Dunmore Homes California sold all of its assets to the debtor entity, Dunmore Homes, Inc., for only $500. The debtor entity was, of course, a New York entity and filed its petition for bankruptcy in the Southern District of New York. Despite being a New York entity, the debtor had no office, employees, or bank accounts in New York. Its only presence in New York was its recent incorporation in the state. Several creditors, including one of the home builder's sureties, moved to transfer the case back to the Eastern District of California. Now, before getting into the factors the court applied, it's important to note that some of the circuits do apply different factors, or they would weigh them differently. However, the Dunmore Homes Court nevertheless provided a great discussion of the factors that a court may consider when analyzing a request for change of venue under Section 1412. Specifically, the court provided a thorough analysis of 7 factors to consider when a transfer is appropriate in the interest of justice. While all of them are on the screen, among others, the court considers judicial economy, the ability to receive a fair trial, and deference to the debtor's chosen forum. The court also analyzed 6 factors to consider when a transfer is appropriate for the convenience of the parties. Things like the proximity of creditors and witnesses factor in here. In seeking the transfer, the creditors argued that the debtor had no business operations in the United States outside of California, and that the creditors would be burdened traveling to and from New York for case-related matters. They also argued that the debtor was blatantly forum shopping with an intent to harm the creditors. The debtor, obviously in favor of maintaining venue in New York, argued that significant weight should be given to the debtor's choice of venue, that the percentage of debt held by creditors outside of California was significant, and that the bankruptcy was really about complex funding and or winding down the operations of the debtor that would be better managed by the New York court. Ultimately, the court granted the motion to transfer venue despite the fact that the debtor had satisfied Section 1408. The court considered the 13 factors for evaluating the convenience of the parties in the interest of justice, and the court focused especially on the location of the debtor's management, employees, offices, and location of the parties in interest, all of whom were in California. It also mentioned the debtor's lack of ties to New York, citing the thin nexus of the debtor to New York and the overwhelming contacts with California, combined with the ongoing reorganization efforts in California, satisfied the movement's burden of establishing the convenience of the parties, and that the interests of justice were better met in California. Now, in another example of forum shopping involving the Winn-Dixie supermarket chain based out of Jacksonville, Florida, there, the company, the grocery store, formed a New York entity shortly before filing the bankruptcy, despite its headquarters and the majority of its operations being based in Florida. The court there concluded that transfer under Section 1412 back to Florida was appropriate solely because the Winn-Dixie affiliate entity was formed solely to establish venue in New York. Obviously, the court there took a dim view of creating an entity for the sole purpose of establishing technical compliance with Section 1408. And I do want to bring up one last example where a court decided to maintain the debtor's chosen venue in New York despite the presence of many 1412 factors. In the infamous Enron bankruptcy, the court in New York denied a transfer to Texas despite all but 3 affiliated debtor entities having their principal place of business in Texas, and the fact that several of the creditors were located in Texas. So as opposed to Dunmore Homes, the court in Enron concluded that Enron's finances were extremely complex, that they would need access to capital markets and financial experts, and therefore the parties most essential to the reorganization efforts were located in New York. And so that's it. Thank you for watching today. Please feel free to reach out with any questions. My contact information is there on the screen. Of course, many thanks to Chad Schneckschneider and Michael Collins for all of their hard work in organizing the book and putting this blog series together. Thanks again to my colleague and law partner, Allie Adams, as well as my colleagues Rob Graham and Alston Merritt for their help in drafting and editing our chapters, as well as assisting me with this blog. Thank you. Have a great day.